Thank you all again for joining today's webinar brought to you by the Tribal Law and Policy Institute and the Tribal Judicial Institute at the University of North Dakota School of Law. Today's webinar is titled Pretrial Release Hearings, Setting Bail and Conditions in Tribal Criminal Courts, and will be presented by Stephen Pavar, consultant with the Tribal Judicial Institute. I will now turn it over to Stephen to introduce himself and get us started.
Well, thank you so much. Do you have control over the video to show my face, or is that something I have?
Actually, that should be you, Stephen, if you are able to click
Yeah,
on the video button.
No, when I click on the video, it says it's disabled by the host.
Okay, we'll see if we can get that fixed.
Ah, great, wonderful. Well, thank you so much. I want to thank TJI and TLPI for inviting me to present this webinar. And I want to thank you all for joining in. I'll do my best to make it worth your while. As we know, the webinar is devoted to pretrial release hearings in tribal criminal courts, bail, and conditions of pretrial release. And there's 7 topics that we'll be discussing as part of this webinar. And very quickly, they are a historical background on the U.S. Constitution and the right to bail. Then the primary purpose of bail in our judicial system, the difference between bail and bond, the factors that tribal judges consider in setting bail, and the importance of a well-drafted order on bail conditions if the tribal judge imposes those conditions. And then we'll look at federal laws pertaining to bail in federal courts. We will then discuss whether our bail system is discriminatory. And finally, we'll look at how tribal courts have actually been implementing bail decisions or making bail determinations. All right, so let's look at the historical background first. And I like history. I think it's important to place this subject in its context. Don't worry, there's no extra charge for this historical information. But keep in mind that in 1787, when the U.S. Constitution was signed, the vast majority of governments in the world, and indeed throughout history in the world, were autocracies. In an autocracy, one person is in control of everything. That person decides what rights people have, if any. So the Greek and Roman emperors, the emperors of China and Japan, the kings and queens of Europe, the Russian czars are obvious examples of autocratic or monarch rule. When the colonists defeated the British in our Revolutionary War, they then needed to decide, well, what kind of government will we have? There had been relatively few democracies in the world. But fortunately for us, the vast majority of native tribes, the Indian tribes, were democracies. Indeed, the Iroquois Confederacy, which was the largest and most powerful group of native nations in the Northeast where the colonists were, had a confederation. Much like what the framers of our Constitution wanted to create. There were 6 autonomous, powerful tribes, just like there were 13 new states in having defeated Great Britain. And we were able to look at the Iroquois Confederacy for ideas on how to form our Constitution. In fact, in 1988, Congress passed a joint resolution acknowledging the contribution that the Iroquois Confederacy made to our government and our way of thinking. Benjamin Franklin patterned the Albany Convention, which later morphed into the US Constitution, on the Iroquois Confederacy. Unfortunately, most of us aren't taught this very important and significant and rich history that the Native nations made to US government. In any event, the framers decided to not have a monarchy, not have a king, a powerful president, and instead created the US Constitution with three co-equal branches of government, one balancing and checking the other two. So the twin goals of the US Constitution were, on the one hand, to create a democracy, one of the first that the outside world, outside of the Native nations, had ever seen, and also to guarantee liberty. And I want to stress the fact that a democracy, which has as its buzzwords the majority rule, is actually a dangerous government. It's a totalitarian government, not by one person, but by one group, the majority. Any majority can wipe out the rights of all minority groups. We only have to look around the world today to see how horrific some ethnic majorities or religious majorities are. So in our Declaration of Independence, we carved out two goals. One is to create a democracy, and the other is to guarantee liberty. So the framers of the Constitution had two overarching goals: democracy and liberty. And our Constitution creates a democracy by such things as having periodic elections. All of our leaders are elected at particular intervals. But then they also wanted to guarantee that no majority can ever wipe out certain inalienable liberties of minority groups. And that's where the Bill of Rights comes in. So in most governmental matters, the majority rules. But the Bill of Rights ensures that even the majority can never take away certain rights that you have as individuals, whether it be free speech or worship or protection against cruel and unusual punishments, the rights that are enumerated in the Bill of Rights. Well, one of these is the right to be free of excessive bail. And that's guaranteed in the Eighth Amendment to the Constitution. The Bill of Rights is the first 10 amendments. This is the Eighth Amendment. And it provides excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, we often say, and I will probably say during this webinar, right to bail. That's not exactly what the Eighth Amendment says. You don't have an absolute right to bail. We have a conditional right to bail. We have a protection against excessive bail, not a guarantee of bail in all circumstances. So the Eighth Amendment, as the Supreme Court has repeatedly recognized, does not guarantee an absolute right to bail. It merely states, but does so significantly, that an unnecessary restriction on bail will violate the Eighth Amendment. And that's protected by the Due Process Clause with respect to state governments. All right, so here's an important question that the Supreme Court needed to address and did address in 1896. And that is, all right, the Bill of Rights was designed to guarantee these individual liberties. Does the Bill of Rights apply in tribal courts? If you are in a tribal court and the tribe denies your right to bail or free speech or any of the other rights enumerated in the Bill of Rights, is the tribe violating the U.S. Constitution? Well, in 1896, the Supreme Court held that Indian tribes are inherent sovereignties. They create their own laws, and they can run their tribal courts however they wish. So you do not have federal constitutional rights in a tribal court. Congress, over time, wasn't happy with that someone in a tribal court might be denied the liberties that are contained in the Bill of Rights. So in 1968, Congress passed the Indian Civil Rights Act, and there have been other webinars about ICRA, the Indian Civil Rights Act, and I won't have time to go into it at length. But ICRA is a controversial law. It dilutes tribal sovereignty. It imposes on every Indian tribe within the United States the obligation to confer nearly all of the rights contained in the Bill of Rights on any person under tribal jurisdiction. So Congress passed ICRA in 1968 and imposed nearly all of the guarantees in the Bill of Rights on Indian tribes. So it's still true that you don't have federal constitutional rights in a tribal forum, but you do have federal statutory rights under the Indian Civil Rights Act. And one of these is the protection against excessive bail. So Congress, when it wrote ICRA, essentially incorporated verbatim the Eighth Amendment. And Section 1302A7A of ICRA provides no Indian tribe in exercising powers of self-government shall require excessive bail, impose excessive fines, or inflict cruel and unusual punishments. So Congress placed the Eighth Amendment into ICRA, and all persons subject to tribal courts therefore have this federal statutory right that is identical to the constitutional rights that they and others would have in a state or federal court. And this protection applies to all criminal defendants in tribal court, whether being prosecuted under any tribal law or under the Tribal Law and Order Act or the Violence Against Women Act. Let's now turn to the next topic. What is the primary purpose of bail? Bail serves two goals simultaneously. First, bail helps preserve our civil liberties. Under the U.S. Constitution, all persons are presumed innocent. So it doesn't make sense then to arrest somebody and immediately incarcerate them without any opportunity for release, given that they're presumed innocent. So one purpose of bail is to preserve our civil liberties by permitting criminal defendants to remain free, maintain their normal lives, their family lives, their work lives, consistent with their presumption of innocence. But as we'll see in just a moment, there are certain times when bail would be denied. Again, both ICRA and the Eighth Amendment protect against excessive bail, not absolute bail. The second goal of bail is to protect society by providing a financial incentive for criminal defendants to return to court. There are certain defendants that unless they put down some money or somebody puts down some money, that there's some loss that they might suffer, might not return to court. So bail serves the purpose of deterrence and helps ensure that criminal defendants will return for the day of trial. And it does these two things then simultaneously. The next topic is, what is the difference between bail and bond? And sometimes these words are used one with another. But there is a distinction. Both bail and bond money have the same effect. They allow for the release of the defendant from jail pending the outcome of trial, but they are different. Bail is money paid out of the pocket or by the defendant, whereas bond is money posted on behalf of the defendant by someone else. And in just a moment, I'll explain how people actually get these bonds. Usually they have to pay for it. But those are the difference. And not only do both bail and bond have the same effect, they also have the same consequences if the defendant fails to show for trial. So if you fail to appear for trial, or you don't comply with the conditions set by the tribal court, it can result in a forfeiture of the bail money or the posted bond. Each tribe, of course, is free to offer or not offer bail or bond, and there are options that tribal courts and other courts have. And now let's look at those options. Under bail, one option, and the most common, is cash bail. Let's say bail will be set for $1,000 and the defendant will remain in tribal jail unless the defendant posts $1,000. Another option is secured bail. That is, it's secured by property. Someone could give the title to a car or title to a house or some other valuable if the tribal court permits this. So the bail would be secured by some property. Another option is unsecured bail. That is, the defendant doesn't have to put any money down, but must promise to pay the money if they default and fail to show up. Another option is ROR, release on one's own recognizance. And this is frequently used in all courts, especially if the crimes are not that serious and the defendant has ties to the community. It's not likely that the defendant is going to flee. With respect to bond, there's two basic varieties. One is that the cash is posted by this third party for the full amount, and some courts allow a percentage to be posted on behalf of the defendant with a guarantee, a promise, that the remaining amount will be paid if the defendant fails to show up. Now, after trial, when the defendant has met the conditions of bail, bail money is then returned by the court to the defendant. Some courts hold a small percentage as an administrative fee, but essentially, bail is returned to the defendant. Not so with bond. And this is one of the main differences between bail and bond. In order to obtain a bond, the defendant normally has to find someone, often called a bond company or bondsperson or bondsman, who is willing to post the full amount of the bail, and the defendant must pay a percentage. Often it's at least 10%. So for instance, if the court sets $10,000 as bail and the defendant doesn't have $10,000. They can go to a bondsman who will say, okay, I will post that $10,000 if you give me 10%, $1,000. At the end of trial, when the money, the $10,000, is returned to the bond company keeps all of it and does not return the $1,000 to the defendant. So most defendants who can afford to post bail do it because they'll get the money back. Whereas people who cannot afford and must go to a bondsperson, they lose their money at the end. Let's now go to the next topic, which addresses the question, is there a time limit on a tribal court setting the bail amount? Now, as we just explained, the right to bail is guaranteed by the Eighth Amendment and also by the Indian Civil Rights Act. Another amendment, the Fourth Amendment, guarantees us that we cannot remain incarcerated without a prompt showing of probable cause. So in 1991, the Supreme Court was finally asked, well, what does prompt mean? How quickly must there be this probable cause hearing? And in the McLaughlin case, the Supreme Court held that barring some other unusual circumstance, every person arrested and detained must be afforded a PC, a probable cause hearing, within 48 hours. After McLaughlin, many states either passed laws or amended laws to require that bail also be set within 48 hours. And it made sense. It's practical because normally the defendant is there. The court will just have just heard evidence about the crime, found probable cause. If they didn't find probable cause, the defendant is released. So the court has now found probable cause. And it would make sense, for common sense, for the court to then go ahead and decide the issue of bail. And many states have enacted statutes that require exactly that, that at the conclusion of the probable cause hearing, bail will be set. However, this 48-hour deadline might not apply to bail, and indeed, the U.S. Supreme Court hasn't addressed the question of whether there is a deadline under the Eighth Amendment or the Indian Civil Rights Act to decide the question of bail. Nevertheless, although many states do impose a 48-hour deadline, the prevailing view is that the Eighth Amendment doesn't require bail to be set within 48 hours. And one of the more recent decisions is from the Seventh Circuit Court of Appeals, and I've put a quotation from that decision. Plaintiffs argue that Supreme Court and circuit precedent requires a bail hearing within 48 hours after a suspect's arrest. We disagree. And indeed, quite a few states have passed statutes that allow courts in that state to take longer than 48 hours. And I've put a few examples here. Ohio, 3 days are allowed. New Mexico, 5 days. Arizona, 7 days. There's a federal statute that we're going to look at in a couple minutes, the Bail Reform Act of 1984, and that too doesn't require that bail be set within 48 hours. So even Congress does not believe that the Eighth Amendment imposes a 48-hour deadline on the setting of bail. All the Bail Reform Act says is that bail must be set immediately upon the person's first appearance, which would be that probable cause hearing. But the act authorizes the prosecutor to request even a 5-day extension. So as we discussed, Congress statutorily imposed nearly all of the Bill of Rights on tribes through ICRA. Given that even federal law, as interpreted by federal courts, doesn't impose a 48-hour limit under the Eighth Amendment, we can safely presume, I believe, that nor does the Indian Civil Rights Act, that if an Indian tribe were to take 3 days, 5 days, 7 days, they would not run afoul of the Indian Civil Rights Act. Again, that has not yet been decided either by the Supreme Court with respect to the Eighth Amendment, nor any federal court with respect to the Indian Civil Rights Act. All we know is that there is some line in the sand. I tried to find some cases under the federal Eighth Amendment, and the closest that I found was a federal decision in Colorado where a defendant had been arrested and not given a bail hearing for 15 days. And she was suing for damages. And the court there said that 15 days does raise a constitutional claim under the Eighth Amendment. So the only advice I can safely give to tribal courts is that you should have bail hearings as promptly as you can. 15 days might be too much, but 7 days is probably permissible, but don't quote me. I don't want to see my name in some court decision. PVAR says that it was okay. But based on the case law, it would seem as though tribal courts have some leeway in when they have their bail setting. Our next topic is, what factors does the court consider in setting bail? And most tribal codes, and I went online and looked up quite a few, like most state codes, rely on the following factors, either some or in most cases, all of the following. One is the severity of the crime. And that makes sense. I mean, if somebody is facing a long period of incarceration based on a serious crime, they might be more inclined to flee. So you might want to impose higher bail based on a serious offense. Another is the defendant's criminal history. If this is the first offense, or if this is a repeated offense and the defendant has always shown up for trial, that may factor into the amount of bail. Another is the likelihood that the defendant may flee. In other words, the defendant's ties to the community. If this is an outsider who lives out of state or on another reservation, that might factor in, as opposed to, let's say, the defendant has always lived in the community, has children going to school, is married and works in the community. That might balance in favor of a lower bail. And next and last is public safety. What has this defendant done? Are there any threats, for instance, against a potential witness in the case? Do we have to protect the public from this person? Many courts, both federal, state, and tribal, decide to impose conditions on bail, which they can do. You may require the defendant to wear an ankle bracelet, or to give up a passport, or to see a supervisor, like a parole officer, periodically, or prohibition against contacting an alleged victim. It's important, of course, for tribal release orders to be very specific on this. Because if you're imposing a condition, then theoretically you're doing it for a reason, and you need to detail that reason, not only to notify the defendant what conduct is impermissible, but to provide a guideline so that if the defendant were to engage in that impermissible conduct, you'd be able to revoke bail and place the defendant in jail. So that's very important, that you identify the conditions of bail. Now, each tribe decides for itself what factors to consider. And some tribes, as we'll see in just a moment, leave it up to the court and don't impose by statute or ordinance factors. I spent some time looking at various tribal codes, and I've selected 4 for you to just take a look at. The first is the Navajo rule, and this is a quotation. You'll see that the Navajo legislature has decided to be pretty specific on the factors that its courts should consider, but it's broad discretion. And if there is reason to believe that the defendant is dangerous to public safety, or that the defendant will commit a serious crime, or will seek to intimidate any witness, or will otherwise unlawfully interfere with the administration of justice as is released, or for any other reason allowed by law, then the court may deny release or order the defendant to abide by any other conditions necessary to the orderly administration of justice. So a broad grant of discretion to the trial court, but the command that the court must state the reasons for denial of bail on the record. Here's the Chickasaw. You'll see that they have 9 factors. And by the way, as Chantel mentioned, this PowerPoint will be available. I'm not going to read these 9. You can get the PowerPoint. In addition, I submitted written materials that contain the full citations to all of this, including the full citations to all cases, and you're welcome to get those written materials. So the Chickasaw have listed 9 factors that its courts can consider, and all of them fall into really the ones that we looked at. Although here, you'll see number 2, the court is permitted to consider the likelihood of conviction. And number 9, or number 8, the identity of responsible members of the community who would vouch for the person's reliability, which invites a defendant to have people in the community appear at the bail hearing and vouch for the defendant's credibility. So the Chickasaw have 9 factors. Here are 2 tribal courts that have basically the legislature has decided to basically leave it up to the court. The Rosebud Sioux tribe states that each court must set appropriate bail, but there are no factors that the court can consider. The code simply states that the defendant may be released ROR upon his promise to appear before the court at the time set for such appearance. And similarly, the Eastern Band of Cherokee have a provision granting bail on the and the conditions of bail shall be in the discretion of the court. So there's a wide variety of provisions in the various tribal courts. Now let's go to the next topic and quickly look at what Congress has done with respect to the federal courts. And I mentioned that a couple moments ago that Congress addressed this in detail in 1984 by passage of the Bail Reform Act. And you see the official citation there. Under federal law, the defendant must be released ROR unless the court makes certain findings. So there's a preference or a presumption that bail will not be required. However, the judicial officer has discretion in determining whether any of the following factors are present. So subsection B of the Act says that must release the defendant either on personal recognizance or unsecured appearance bond, unless the officer determines that those options would not reasonably assure the defendant's appearance at court or will endanger public safety. If the court does make one of those findings, then another provision of the Act comes into play. And that's where Congress has placed factors that the court can consider. And here again, I'm not going to go through this in order to save time, but you'll see that basically it's the same factors that we just reviewed: the seriousness of the crime, the character of the defendant, the weight of the evidence, and whether anyone in the community would be at risk. Now, at this point, I want to take a few minutes, and I feel I would be remiss if I didn't do this. I'm somewhat of a social reformer. I care about social justice, and I wanted to raise an issue for tribal officials and others just to think about. I'm not making any recommendations nor any preferences, but there's an important issue with respect to bail. And the issue is whether our bail system is discriminatory. And let's take a look at the facts. Every single day, including today, there are more than 600,000 people incarcerated in the jails in the United States and scores in the tribal jails. And according to a 2015 report from the Vera Institute, and again, my written materials contain the full site, the majority of these 600,000 are pretrial detainees who are in jail only because they cannot afford bail. And 3/4 of them were arrested for nonviolent offenses. So please appreciate this fact. A judge has already determined that these people can be released safely, because otherwise bail would have been denied. They can be safely released. They just need an incentive to return. And the only reason why they are still there is because they're poor. Many people view this as wealth-based discrimination. After all, people who cannot make bail typically suffer severe consequences, not just the denial of liberty, which is severe enough if any of you have ever been in jail or visited people in jail, it's traumatic, losing one's liberty. But more than that, or on top of that, as the Vera report noted first, incarceration, even for a few days, can have dire consequences, such as being fired from employment. You don't show up for your job, or your rent is due and you can't pay it, or loss of child custody. One of the cases that I litigated was on behalf of the Oglala and Rosebud Sioux tribes regarding the application of the Indian Child Welfare Act. And we sued the South Dakota Department of Social Services on behalf of those tribes and individual parents in federal court. And one of the issues in our lawsuit concerned the fact that South Dakota was not having prompt hearings and fair hearings after someone had their children taken away. And many of those instances concerned people who were arrested. Let's say that there was a domestic disturbance, or mom was arrested for driving under the influence, or dad was arrested for anything. And especially in cases where it's a single mom or a single dad, and they're in jail even for a couple days. Well, what do you do with the children? And time after time, the welfare department swooped in. And once, and I'm using some pejorative terms here, but I feel this way, once they got their clutches on these Indian children, it was very difficult, we found, to get them to return those children. So I know from personal experience of meeting hundreds of Native families who have lost their children in instances where mom or dad or both were incarcerated even for a few days. This can have very profound ramifications. Second, incarceration can leave permanent psychological scars. And that's particularly true in Indian country, where tribal jails are often brutally substandard. I participated in a TJI conference last year discussing the conditions of tribal jails, and they are horrible. So not only is it always bad to be incarcerated, but it can be particularly onerous in a tribal jail. And third, pretrial detainees who cannot make bail are often inclined just to plead guilty to get out. They can often stay in jail pending trial longer than their sentence would be if they plead guilty, especially for minor offenses. So the loss of bail is often an inducement to plead guilty when you're not even guilty, and you have to waive your right to trial. Moreover, this whole bail system has spawned the growth of these bond companies that earn an estimated $2 billion a year off the backs of poor people. I'm not saying that they don't perform a function. If I were poor and I wanted to get out of jail and I could come up with 10%, but not the entire amount, it would be a godsend. I'm not saying that they don't serve a purpose, but if there were no bail at all, or if the bail were reduced and I could make it, so much the better. And you have to remember the fact, as I explained earlier, that at the end of trial, bail is returned to the defendant. So a wealthy person or wealthier will get the money back, but a poor person won't. All right. There's just lastly on this point, and then I'll get off my soapbox. There are reforms available and some states and tribes have begun experimenting with them. Illinois abolished cash bail entirely 2 years ago. And now everyone is released unless the court finds that it would endanger the public. And studies since then have shown that crime has not increased, regardless of what the defendant has been arrested for. Releasing that defendant has not resulted in more crime for the community. Another, New York is experimenting with supervised release, much like parole, where you report to somebody or you wear an ankle bracelet. And Connecticut is trying that no one will serve more than 14 days in jail if they cannot afford bail. They will then be released ROR. In other words, there are alternatives that tribal courts have, lowering bail, no bail, release under supervision. All right, well, far be it from me to recommend anything to a tribal court. It is certainly the prerogative of each tribal court to determine its own system of bail. But I just wanted to raise this issue and so that we can all think about it. The final topic, and then we'll stop and solicit questions. The final topic is how have tribes been doing, or tribal courts been doing with respect to bail? And case law, I spent a number of hours looking at tribal court decisions regarding bail and federal court decisions reviewing tribal court decisions show that tribal courts have been very respectful of bail and sensitive to the reasons why bail was created in the first place. And I have a couple of court decisions here. Here again, the written materials contain a full citation and discussion of these cases. In 1998, the Hopi Court of Appeals reversed a lower Hopi court decision that imposed a high bail because the judge didn't explain why this defendant was stuck in jail due to this high bail. And the court explained any restriction upon the defendant's liberty, which is greater than the amount necessary to provide reasonable assurance of appearance at trial, is inherently punitive, i.e., it's excessive. Another tribal court decision that I found came from the Navajo Supreme Court, which, like the Hopi court, held that a person who cannot meet bail and is stuck in jail and who challenges the bail as excessive, that amount will be overturned unless the government, the Navajo government, shows clear and convincing evidence, and this is a quote from the decision, that the high bail is necessary. So that's a high burden of proof, way more than preponderance of the evidence, way more than reasonable evidence, that the government must prove in the record itself, available for review by an appellate court, that a high bail is necessary in this instance. Similarly, the Colville Confederated Tribes Court of Appeals held something similar, that access to bail is a question touching on a defendant's fundamental rights, and therefore the judge needs to state on the record the basis of her decision to impose a money bail and not to simply release the defendant. And the court's findings must support the amount set. So as many of you probably know, the Indian Civil Rights Act has a remedy provision. It's 1303 of the Act, and it provides that federal courts can review the decisions of tribal courts if the person is being detained, is incarcerated. So obviously, someone who cannot make bail is denied bail, is incarcerated, and would have that vehicle, that remedy available to them. They could ask a federal court to review a bail decision by a tribal court. Well, I spent a long time and even asked a Westlaw reference attorney to help me in this research because I wanted to be accurate, to try to find any federal court decision addressing a appeal or a review of a tribal court bail decision, and we couldn't find one. That indicates, now granted, not everyone in a tribal jail would know that they could appeal a decision to a federal court, but the fact that there aren't any federal court decisions addressing whether a tribal court abused its discretion under the Indian Civil Rights Act strongly suggests that tribal courts are doing a very good job in implementing this aspect of the Indian Civil Rights Act and imposing fair bail. Well, that's it. I'll be happy to answer questions. One shameless plug for my book. Some of you are familiar with it, but for more than 40 years, I've written and updated a book called The Rights of Indians and Tribes. And last year, I published the 5th edition. And the web address is www.therightsofindiansantribes.com. John Echo Hawk from NARF wrote a foreword to this edition, and on the back cover, 15 tribal advocates and some judges like B.J. Jones have endorsed or recommended the book. That's all I'm going to say. If anyone's interested, there's the website. All right. So questions. Happy to answer any questions that you may have. And once again, I want to thank the sponsors for giving me the opportunity to discuss this important topic with you all.
Thanks, Stephen. I do think we have a couple of questions, so I'm going to just kind of look through them in the chat. The first one that we had was, does anyone ever have the feds ask tribal courts to detain someone and not release due to an ongoing federal investigation, or in the alternative, ask them to have a cash bail until the federal investigation is done?
I can certainly see that happening. I see that the question was asked to tribal judicial officials, and maybe one or more can answer that.
Okay, thank you. Yeah, I think there was some answers in the chat, and I think we can also follow up on that as well. So I'm going to look and see what else we have.
There was another question asking if there's been any problems with prohibitions against alcohol and drug use on conditions of release.
And again, it's certainly a condition after conviction. The vast majority of parole or probation release orders prohibit that. I've seen it in some bail conditions, especially if the crime itself involved drugs or alcohol. But because the person is presumed innocent, it's not I don't think it's the majority view, but again, I haven't looked at hundreds of bail orders. And maybe somebody connected with a tribe can answer that even better than I could.
Yes, I thank you.
Just to jump in on that, Stephen, one of the tribes that I worked with as a prosecutor and attorney, they had a long-standing tradition of being a dry reservation. So alcohol was actually illegal to possess on the reservation. And for that particular tribe, it was very commonplace for a condition of bail to include, that an individual could not possess or consume alcohol.
Good, thanks.
Yes, I'll add to that as well. I think in general, there's a set of standard conditions for release that courts can use if they have adopted into their codes or even the policies within the court. But generally, when you have your arraignment or your bail or bond hearings, those are things that the defendant or the attorney and prosecutor can bring to the court for consideration and make argument, as well as if there's a pretrial release report with recommendations on any of that criminal history or background for the judge to make those determinations. So I think those are helpful. If the courts don't have those types of rules, they should probably be considered. And then I would also ask Stephen if there's information that you could share regarding forfeiture of bail or bonds that might be useful, or if you have seen any issues where that has come up, where tribes have been challenged with forfeiture on bails or bonds.
I haven't seen any challenges in the case law, and I haven't read about any, but those of you who are involved in tribal courts can chime in on that. But this goes back to what I was saying on the importance of having very specific tribal court orders, release orders. And you can then say that if you were caught drinking or leaving the jurisdiction or sending emails to the alleged victim or a witness, you will forfeit your bond or bail. Forfeiture is more, and fines are more challengeable if the tribal court order is vague and not where the defendant is specifically warned. We will consider forfeiting your bail if you do X, Y, or Z. And both state and federal courts and tribal courts enforce that and have a right to enforce it.
Thank you, Stephen. I do think we have a couple of other questions, but I'm not sure they're on topic for this webinar. So we could follow up with those regarding fees and fines and collections of such. So I think we can respond to those maybe separately. And I just want to give people any further opportunity if they have any specific questions regarding this presentation.
While we're waiting for questions too, I did want to share that the Tribal Law and Policy Institute had a recent publication titled Promising Practices in Intergovernmental Collaborations that highlighted St. Regis Mohawk and the Town of Bombay Court's pilot project, which was it was a native bail reform pilot program that was funded by the Department of Justice Coordinated Tribal Assistance Solicitation Grant back in 2017, but they participated in a first ever tribal state court collaboration on bail reform, on a bail reform initiative. So I will share that publication in the link for anyone interested in learning more about that in the chat.
Thank you. And I will note that Judge Whistler from Southern Ute put in the chat that there was a recent tribal appeals court rule that the only reason for forfeiture of the money was for failure to appear. and that violations of other conditions can result in revocation of bond, but not a forfeiture. And I think that some of that, again, goes to what is in your code. So if you're doing things administratively and it's not actually within your code, that could be a reason for an appeal, because your defendant might find that it was done unlawful. Okay, and for the question, that's Southern Ute Tribal Court for Judge Whistler. Okay, and then we just had an extra question of any further information or studies regarding pretrial release to treatment when bail is sought or ordered. And we can look for more information on that and send it out in the resources if we have that available. Okay, all righty, we don't seem to have any questions in our Q&A box, and I don't see any further questions in the chat. So we'll go ahead. We do have the evaluation link there on the screen. So I will say thank you for attending today's webinar, pretrial release hearings, setting the bail and conditions in tribal criminal courts. And thank you to Stephen and our partners at TJI for joining us today. Again, the webinar recording will be posted on walkingoncommonground.org and will be sent out to our mailing list. If you could take a few minutes and click the link in the chat or the QR code and fill that out, we would appreciate it. This webinar is a part of a series of monthly webinars to support the development and enhancement of tribal courts, tribal justice systems, and intergovernmental collaborations. These webinars are brought to you by the Tribal Law and Policy Institute, the National American Indian Court Judges Association, and the Tribal Judicial Institute, UND School of Law. The next webinar will be on Wednesday, April 30th. Please save the date and we will send out more information when that's available, including registration. And again, thank you guys for joining us today. We look forward to seeing you next month.